Madam Chair, I want to build on the questions from Congresswoman McClain, if I could. Ms. Murko, the D.C. Circuit's decision in Alpine Securities versus FINRA addressed FINRA's authority and oversight. What did the court decide, and what acts should Congress take from that ruling when considering SRO reform?
Congressman, I'm so glad you asked this question because it ties directly into recommendation 3 of my written testimony, which builds indeed on the court case, whereby I recommend that the Exchange Act be amended to require SEC review before every FINRA bar or expulsion decision becomes effective. Fundamentally, Alpine is about the ability to bar and expulse. The Supreme Court did not review it. It's making its way through the court system. So importantly, what we should focus on now is how to make sure that every bar or expulsion decision is reviewed or approved by the SEC, and that requires an amendment by Congress to the Exchange Act. By requiring the SEC's review of these bars, individuals would receive the benefit of an additional and necessary layer of government oversight, helping to better safeguard Fifth Amendment rights. And this is both individuals and firms. The reality is that today, if a firm is subject to a bar or an expulsion, there is a process through which they can request SEC review. Individuals do not have that. So there needs to be an equalizing of those two things, and Congress should indeed amend the Exchange Act in order to have that put into place. The other thing that I really wanted to note on this front is there's always the question of, well, what if it's an emergency? What if something needs to move quickly? SEC review could take a while. So I really wanted to note that as part of my recommendation, I added an additional layer of investor protection recourse in the event of egregious misconduct. This would allow for FINRA to ask for a temporary restraining order or preliminary injunction, but this is the important part, through an appointed Article 3 judge. The goal here is that either the SEC or, in the instance of a more emergent matter, a court and an Article 3 judge make the decision on whether a bar or expulsion should happen.
Thank you. Professor, I want to ask you, what specific reforms should Congress consider to improve FINRA and the MSRB while preserving the benefits of industry participation in regulation?
I think that, thank you for your question. I think the general theme here is more transparency, more disclosure, and more accountability. And my sense is that the best way to do this is through the existing structure of the Exchange Act, much as the SEC has required for-profit exchanges to change their business model, change their governance, improve transparency, particularly with respect to the use of fines and their allocation for budgetary purposes. The SEC has demonstrated it has the ability to do this, whether by individual application or whether by rulemaking. I think the SEC is in a position to do the same thing with FINRA. I think the job of this committee and the job of Congress is to hold the SEC's feet to the fire and make sure that it does its job.
And with that, Madam Chair, I'll yield back.